to Employment Bite. In this series, our London employment team provide bite-sized overviews of some of the key developments surrounding the employment law landscape in the UK. Whether you're an employer or an employee, join us for a discussion navigating the dynamic world of employment law. I'm Doubleday, and I'm joined today by Alice Whitehead. And this is the third part of our series on the Employment Rights Bill. Today, we're discussing how the bill will change an employer's obligations in a collective redundancy situation. So, just to set the scene, Alice, please could you tell us what is a collective redundancy situation?
So, at the moment, a collective redundancy situation is one where an employer is proposing to dismiss 20 or more employees at one establishment within a 90-day period. The employer then has to consult with employee representatives, either a recognised union or elected representatives, before any dismissal can take place. How long that consultation lasts depends on how many dismissals the employer is proposing. If it's less than 100, it's 30 days of consultation, but otherwise it's 45 days.
Thanks, Alice. And could you also explain whether that means that if the dismissals aren't at one establishment, there's no duty to inform and consult?
That's right. Although the legislation doesn't define what amounts to an establishment, it's normally an employee's physical place of work. There could be situations when a sales team or business department is structured in a way that makes it an establishment, but it's more often the actual place of work. What that means is if you've got employees split over several sites, it's less likely that they're going to be entitled to collective consultation in a redundancy situation. That has been quite important in some cases. Ellie, can you talk us through how this impacted Woolworths?
Yes, of course. So when Woolworths went into administration, there were lots of individual stores that didn't employ 20 or more people. And because each store was an establishment, the employees working in those smaller stores didn't have consultation rights. And in turn, this meant that they weren't eligible for a protective award in the same way that employees working at head office or in larger stores were when their employer failed to inform and consult them. Now, in an administration, that absence of consultation may not affect the eventual outcome, only the right to compensation. And in this case, all the Woolworths stores sadly ended up closing, and consultation wasn't going to change that. But outside of an insolvency situation, excluding employees who work at smaller sites from consultation deprives them of a chance to influence the redundancy process, and that could also make individual dismissals unfair. So the Woolworths case then led to a question about whether the UK had properly implemented the Collective Redundancies Directive, or whether the directive was intended to give employees more extensive rights. Alice, could you tell us about what happened next?
So this legal point went to the European Court of Justice to decide, but the CJEU found that the UK approach was consistent with the directive. As a matter of EU law, there was no need to aggregate redundancies taking place across different establishments before deciding whether the employer had to inform and consult collectively. That settled the position under UK law, but the Employment Rights Bill reopens this issue. It's doing that by removing the words "at one establishment" from the legislation. That means that employers must inform and consult collectively whenever they are proposing to dismiss 20 or more employees in a 90-day period, regardless of where the redundancies are happening. And Ellie, I think that's got some important implications for employers. What do you think?
I agree, because it's going to make it much harder in future to identify when collective redundancy obligations are triggered. So in some cases, it's still going to be fairly straightforward. For example, if head office at a retail chain decides to close 5 stores, that's clearly going to trigger consultation if the closures are going to take place within 90 days. And that will be true even if each store only has 10 employees. So in those cases, it should be relatively easy for employers to identify the need for and to run consultation. But what's going to be more difficult is where you've got decisions being taken at a devolved level within an organisation, which don't have the same underlying rationale. So, for example, you might have 5 redundancies after an HR team is restructured in London, then 10 redundancies in a sales team based in Manchester when it relocates to Newcastle, and a store closure in Penzance affecting 15 employees. And if those dismissals all took place within 90 days, the employer will have to consult employees collectively for at least 30 days, even though the rationale for the redundancies in each case is completely different, and there may not be many issues that are common to the three groups. Also, as a further challenge, employers without a recognised union or existing elected employee representatives will also need to allow extra time to put representatives in place for the collective consultation. And what further challenges do you foresee, Alice?
I agree with you that it really creates logistical difficulties for employers, both in terms of identifying that there's a need to consult in the first place and in terms of running the process. Employers also need to think about completing an HR1 form notifying the government of the proposed redundancies in that situation. In the future, the trigger for filing an HR1 will also be 20 dismissals in 90 days, regardless of whether the dismissals are taking place at one establishment. And what do you think employers should be doing to prepare for these changes, Ellie?
Well, firstly, it's worth noting that although we're not sure exactly when the changes will come into force, it should be shortly after the bill receives royal assent later this year. There's no need for any further consultation on the issue or complex regulations to give effect to it, so the changes could happen more or less straight away. So, it's sensible for employers to begin thinking now about how they are going to keep track of proposed dismissals to ensure that they can identify consultation obligations. That's probably going to require some form of centralised reporting obligation and perhaps someone to monitor timeframes to spot the point at which consultation obligations are triggered. Now, I'd be particularly interested in your views, Alice, but I find that keeping an eye on timeframes is particularly difficult because of the CJEU decision in Markleen a few years ago. What do you think?
Indeed, I agree. What Markleen said is that you've got to take a look back, look forward approach when calculating the number of redundancies in a 90-day period. Theoretically, that means that an employer could have consultation obligations in relation to a dismissal that's already taken place, if the dismissals that take place in the following 90 days mean that 20 or more employees have been dismissed in total. That's what happened on the facts in Markleen. It's fair to say that so far, the courts and tribunals haven't been asked to grapple with the implications of the decision. We've not really seen employees arguing that consultation obligations apply in a much wider range of situations than would have been the case previously. But at least in theory, the case gives rise to difficult practical issues. These are only going to be exacerbated if you have to look at dismissals across the whole business, not just at one establishment. But it's important to remember that it's only dismissals for a reason not related to the individual that are caught, not every dismissal that takes place.
And could you elaborate on whether there's anything else that employers should focus on at the moment in the redundancy context?
Of course. In the shorter term, we're still waiting for the results of a collective consultation exercise the government ran last year. This proposed higher penalties for failing to comply with collective consultation requirements. Currently, the maximum protective award for failing to consult is 90 days pay per employee. That's already a hefty penalty for an employer that fails to take steps to comply. Tribunals can obviously reduce this protective award if an employer has made some effort to inform and consult, even if it hasn't fully complied. The government is now suggesting either increasing the maximum protective award to 180 days actual pay per employee, or simply removing the cap entirely and allowing tribunals to exercise their discretion about what is an appropriate sum in any case. Either way, it raises the prospect of a significantly greater penalty if an employer doesn't meet its consultation requirements, when the underlying duty to consult will apply to more dismissals. So that's in the shorter term, but Ellie, could you elaborate on the longer term proposals?
Yes, so in the slightly longer term, the government has also indicated that it will increase the minimum consultation period in large-scale redundancies, where 100 or more employees may be made redundant. At the moment, consultation in that situation must last for 45 days, but that period may be raised to 90 days. And that was the relevant minimum period before the Cameron government reduced it in 2013. Now, again, that would make collective consultation longer and more costly for employers. It remains to be seen whether the proposal will go ahead or whether the current drive for economic growth makes the government rethink the suggestion. So that brings us to the end of today's Employment Bite. Thank you very much for joining us. Reflecting the current pace of employment law change, we'll be back with another bite in a couple of weeks. And next time, we'll be focusing on the new right to neonatal care leave that comes into force in April.